Hello, everyone. My name is Sara Papantonio. I'm with Levin Papantonio Rafferty law firm. Joining me today is Chelsie Green, another attorney with our law firm. And today we're going to be walking through the hair relaxer case. What we're going to be talking about is what's happening in the litigation and how you can get involved. So Chelsie, go ahead and give us a 10,000 foot overview of what the hair relaxer litigation is.
Absolutely. So we know last October in 2022, a scientific study was released that kind of sparked this litigation. And that study by Dr. Chang basically said, frequent users of hair relaxers had a doubling risk of developing uterine cancer by age 70. And so from there, as we know, cases were filed all across the country.
Okay, what is hair relaxer? Walk us through that.
Yes. So hair relaxers is a cream or lotion mainly for Black and brown women to make their hair appear straighter. And we know that Black women wanted to achieve this look to be deemed professional, to be seen as acceptable in society. And this stems back all the way to slavery days when, Black women's hair was not accepted.
This has been a hot topic item in politics, in the media, this idea that women have to conform to societal pressures, right? And
Exactly.
So what you have is companies like L'Oreal coming in and just marketing the crap out of this, right? Pushing this narrative that Black women have to have strong hair. And I think it's important to touch on because this is our plaintiff population, right?
Exactly.
So walk us through what, how many people were potentially exposed to this? What does our plaintiff pool look like?
This is going to affect thousands and thousands of women, and it's going to span across generations. Hair relaxers were first made or discovered, invented, whatever we want to call it, back in the 1900s. And then today we have companies who have refined these chemicals and continue to market them, not just to adults, but also to little children, little girls are being targeted to use these products that ultimately affect their development. And as we've seen in the litigation, the reproductive systems of women.
Right. You're essentially affecting a young child's ability to have a child if they develop any of this endometrial cancer, the uterine cancers, the cervical cancers. And so it's a significant problem that these companies have created at an early age. But I'm not familiar with the process. I've got stick straight hair of how often hair relaxers are used and the frequency and the exposure. So what does that look like? Is it different for everyone? Is it?
Absolutely. So yes, it will be different for women depending on how curly or kinky their hair is. But typically hair relaxers are reapplied in what's called touch-ups about every 4 weeks. And some women use them more frequently if their hair is curlier, because what happens is you apply this to your roots, to your hair. It knocks the protein structure of your hair, and then you have new growth and your hair continues to come in. So then you continue to reapply these chemicals to your scalp. And what we know about the scalp, it's one of the most absorbent features or skin that we have.
Right. Yeah, right. And so so you're ultimately absorbing these poisonous chemicals. And let's talk about what those chemicals are. Go ahead and walk us through that.
Yes. So we know that these products, the hair relaxers, contain multiple different chemicals, and some of those are listed on the box. But what's most important here is the fact that we have fragrances listed on the ingredients label, but defendants are not required to tell us what's in those fragrances. And we're finding it particularly harmful to our clients because we believe that that's where the phthalates are. That's where the DHP is. That's where the carcinogens mainly lie.
And this is so important because I believe that this is a start to an attack on the cosmetic industry, and it is absolutely necessary. For those of you who don't know, we have a cosmetic act that has been around for decades and has never been changed or altered. And what it allows is for companies to use poisonous chemicals like formaldehyde, like phthalates, all terrible chemicals that have been deemed to be human carcinogens, right? And they can hide these chemicals in these products under the guise of what is called fragrance. Because tell me exactly how they can do this with this fragrance kind of loophole, Chelsie.
Absolutely. So the FDA is, I guess, mandated with somewhat policing the cosmetic companies, but this act that we're speaking of, it does not require them to list out all of the ingredients in the hair relaxers. So what we are finding is that defendants are using this loophole. They're using this to, I guess, put in the preservatives that increases the shelf life of their hair relaxers, but ultimately it's harming consumers.
Right, because they're hiding under this idea of, hey, the smell of our hair relaxer is because of our fragrance, which is proprietary information. You can't have this information. We don't have to tell you that we are putting poisonous chemicals in this product, right?
Absolutely.
It's insane. And it is in tons and tons of cosmetic products across the country. So I do keep an eye out for that, because hopefully what you guys are doing are paving the way for litigation and protection to come, right?
Absolutely.
And so let's talk about the science, right? Because as an attorney trying to figure out if I want to get in this case, what I want to know is, are we going to make it past Daubert? So what is the general sense there?
Absolutely. So as we alluded to earlier, Dr. Chain's study, right? So in her study with her associates, what was the cohorts that were looked at over a 10 to 11 year period of hair relaxer users and non-users, what was found was that 1.64% of never users were diagnosed with uterine cancer, but frequent users of hair relaxers had a 4.05 chance of developing uterine cancer before the age of 70.
So for lay people like me, that's a doubling of the risk, right?
Exactly.
And that's a key phrase that us plaintiff lawyers like to hear when we're talking about Daubert, right?
Exactly.
Doubling of the risk.
Exactly.
And so generally speaking, I know we're still in early stages, but does leadership here feel comfortable that Daubert will not be an issue?
Absolutely. We've been working with experts since the beginning of this litigation back in October and even before then. So we are very confident that not only will we get past Daubert, but that we will see the success of this litigation to the end.
Absolutely. And we love to hear that. And the next thing we like to hear as attorneys is not just what information we have currently, but what did the defendants know at the time, right? What did they know 10 years ago? What did they know 20 years ago about the danger of their product? Do we have a liability timeline here?
So while we're still working on the liability timeline, we do know that since the beginning of time, defendants have known that their products were carcinogenic and were harmful to women's reproductive systems. We know at least back until 2015 that they had real information that they could have disseminated to the public to warn users so that ultimately the user can make the decision if they wanted to continue using the product or not. But defendants withheld that information. And now we have thousands and thousands of women affected.
Yeah, you actually had interest organizations petitioning the FDA to remove these products from hair relaxers in 2015, 8 years ago,
yes.
Right? And nothing happened.
Nothing.
Which is so typical of our government and is so typical of our corporations. And to put this into perspective, one of the defendants here is L'Oreal, which is one of the biggest beauty conglomerates in the United States. And so what I, tale as old as time, see happen here is you have L'Oreal with backlash by the FDA. The FDA is investigating their product. What do? They put immense efforts, lobbying efforts, into getting that investigation to go away, right?
Exactly.
I would imagine that's what's going to come across in this litigation. It seems to happen in every litigation. But the point here is you had 8 years where L'Oreal knew their product was damaging, knew it was poisonous, and did nothing.
Exactly.
And what we always say at our law firm is that documents here are going to drive damages. And so I cannot wait for you guys to get in the documents and the production here.
Yes, we're excited to get the litigation started. While we're still in the early stages, we are very excited to be in the Northern District of Illinois, and we are going to be able to get this litigation across. And if there are any attorneys out there wanting to know how they can get involved in mass torts, this is one of the cases that you should definitely get involved in.
Yeah, absolutely. So let's break that down for even new attorneys. You said cases are all consolidated in an MDL in the Northern District of Illinois, which is a great jurisdiction. Who's our judge?
Yes, so we're in front of the Honorable Mary Rowland. This is her first MDL, but we've had a hearing in front of her already, and we're very excited to be in her court, in front of her.
Yeah, I mean, one, she's a new judge, which is I think is going to be really beneficial because she's going to come with new ideas and hopefully progressive ideas. And then two, a female judge with majority female plaintiffs, right?
Absolutely, absolutely.
And so that's good. Now there's been one hearing, right? A first CMC,
Yes.
And tell us about that.
So during our first CMC, we had leadership appointed, and we're excited that one of our very own shareholders is appointed to leadership, and will be part of the conversations and moving this litigation forward.
Well, not just part of the conversations, really moving it. And yes. I understand that you are on the Leadership Development Committee as well.
Yes. So I'm very thankful to be part of a litigation that wants to bring up younger lawyers. And so I'll be hopefully, pivotal in moving the litigation forward as well.
No, I don't doubt that. But I think what we can talk about now is some kind of big ticket items. We've briefly touched on the defendants. Generally, how many defendants are going to be implicated here?
There's about a dozen different defendants, but there's going to be mixed use of these products across, consumers. They don't necessarily have a loyalty to one product, while some do, some don't. So we'll have a number of different defendants in this litigation. But what we do know is that there are about 5 major players.
Okay. And one of the big ones is L'Oreal, right?
Correct.
What does their market share look like?
So we know L'Oreal will hold a bulk of the market share just because they're the biggest, cosmetic company out there. But we also have, DeBar International. We have Strength of Nature, and what we're working on is the claims against Revlon, because as we know, Revlon is in bankruptcy. Yeah,
let's talk about that, because if you're a mass tort attorney out there, what you know is bankruptcy is a big ticket item right now. So tell us how the court is handling potential bankruptcy issues here.
Yes, so right now we are working on opening the claims period back up for those potential claimants who have claims against Revlon. So we are working with bankruptcy counsel at the moment to get that established and set up and protect our clients' rights.
And so Revlon right now is really the only defendant with the bankruptcy worry?
Correct.
Okay. But, we kind of have to talk about the bankruptcy issue and really in the sense of the size of litigations, because right now we know that the play of major corporations is to go the bankruptcy route. And so to me, the way we protect that is by creating a very narrow and specific pool of plaintiffs.
Yes.
We've seen with a lot of litigations, unfortunately, the greedy trial lawyer going out and advertising for everything under the moon. I mean, you can have a case where a person hurt their pinky toe and they're filing litigation.
Right.
And we cannot do that here. We cannot do it.
Because we would really hurt the women who were affected by these products by trying to bulk in a number of different injuries into this litigation. This litigation is about uterine cancer, endometrial cancer, and ovarian cancer. And that really needs to be the focus across the country.
I couldn't agree more. I mean, if we allow attorneys to go out and, like I said, get everything under the moon, it is ultimately going to affect settlement values. It's going to affect the people who have true legitimate issues who
Absolutely.
Really need help, and it's going to affect the timeline here. And so what is the exact criteria that you're looking into filing as legitimate cases?
Yes. So based on the study, we're looking at 4 or more uses in a 12-month period, with at least a 1 to 2 year latency period for women who've gone on to develop uterine cancer, ovarian cancer, or endometrial cancer.
Okay. And then if a person isn't a mass tort attorney, or if they are curious of getting involved, and maybe they have contacts in their community of I know these women, these are my mothers, these are my sisters, these are my friends, how do we get them involved in this case? How do we give them the opportunity to really help here?
Absolutely. So the great thing about Levin Papantonio is that we are able to teach firms or lawyers how to get involved in mass torts. And that brings us to Las Vegas. We have a hair relaxer session in Las Vegas this April, which will literally teach young lawyers how to get involved, or teach lawyers of all kinds how to get involved in mass torts. And this is a great project to get involved with, especially because it affects people close to you.
Yeah, absolutely. That program's called Mass Torts Made Perfect. It's in Vegas in April and October. And if you're someone who has always kind of liked the idea of getting involved in mass torts, but been maybe afraid of the sheer volume and numbers and size of it, come to Vegas. Let us talk to you. Talk to Chelsie. Let us walk you through it, because there is room for everyone in this profession, and frankly, we need as much help as we can get.
Absolutely, and I'd be happy to speak with anyone who's wanting to get involved in this.
Okay, Chelsie. Well, thank you so much for talking to us about this case. Please understand that Chelsie is always available to you to discuss this matter further. So thanks.
Thank you for having me.